In the second part of this discussion, we saw what happened in Supreme Court and how the split verdict was given by Supreme Court on the matter of hijab ban or hijab controversy. Now let's see what disturbing questions or what questions of concern are arising, especially in the context of the verdict given by Justice Dhulia. The first point is that Justice Dhulia says that everybody is free to follow his or her religious practice, whether it is essential or not. It doesn't matter. It just be a religious practice. So he or she is free to follow it at public places also, and no restriction can be imposed on this. So the question is, where is the Lakshman Rekha? This is a country where several faiths, several religions are being practiced. So in a classroom, suppose at 10 o'clock in the morning, a student stands up and says that, hold on, stop the lecture, let me have complete silence, because this is the time for me to practice my certain aspects of my religion. After some time, say, certain other student, maybe of same religion or maybe some other religion, stands up and says almost the same thing, that this is a time for my religious practice to be followed by me. So where is the Lakshman Rekha? How the nation will be governed? How the public places will be managed? Especially India is a country where from birth to death, every stage of life is associated with some or other religious practice or formality. Forget the stages of life. We are a country where every day of the week, each and every day of the week is associated with some form or the other form of religious practice and formality. Forget the week, even here every stage or every part of the day, the different parts of the day are also associated with different parts of or with different practices of religion or spirituality or certain other things. So where is the Lakshman Rekha? How the nation will be governed? The second point is that in a case called A.K. Gopalan versus State of Madras, in that Gopalan versus State of Madras, the Supreme Court had said that it is not necessary to refer to the debates which had taken place in Constituent Assembly all the time. But whenever there is a lack of clarity, whenever there is some confusion on certain aspects or the text or the words or provisions of the Constitution of India, then we can definitely refer to the debates in the assembly that time to know the legislative intent behind that article of the Constitution. And in this context, it must be remembered that Dr. Bhimrao Ambedkar had said that when we talk about the right to follow religious practice or religion, the fundamental right, we mean here those practices which are essential to that religion. So the question is why Justice Dhulia did not consider this point. I'm asking it with all due respect and regard to him. My next question is that why Justice Dhulia did not take the global context into consideration. We see that what is happening in Iran, a girl was allegedly brutalized for refusing to wear hijab. Similarly, in some other countries, especially those countries where the larger part of population belong to that particular faith or religion where hijab is an essential matter. In those countries also, several of those countries also, hijab has been banned at some time or the other time, maybe in the present times also. There are certain countries where the population of that particular religion or faith dominates. Their hijab at some time was banned, or maybe today also it is banned in schools also. These countries are Azerbaijan, Kyrgyzstan, Egypt, Tunisia. So Why these references were not taken to by Justice Dhulia? I'd like to mention one country here, that is Morocco. In this country, it is said that there was a book, probably a textbook, and in that textbook a photograph was published in which there was a girl who was wearing hijab. This photograph must be in some context, but the government of Morocco reportedly asked the publisher to remove that photograph. So this is an important point which Justice Dhulia should have thought of. Similarly, one more question comes up in the mind, that is, when Justice Gupta gave his verdict, and when he said that the ban on hijab is a reasonable restriction, he gave a lot of references. In fact, out of 81-page verdict, 56 pages belong to Justice Gupta. But Justice Dhulia appeared to be plainly saying that this ban is not a reasonable restriction, this is unreasonable restriction. But it does not appear to be giving much references, much logic, much ground in support of his statement that it is an unreasonable restriction. We also find that in the courtroom an ambience was created that plurality is very important. So what is the harm if these girls in the classroom, other girls see that, okay, there is something called plurality in terms of, religion or sartorial plurality, that is regarding the dress and the uniform. But here an important point is that all the girls of that classroom, they are watching, they are seeing, they are witnessing these diversities in terms of religion across the country. When they come to the market, they see this diversity. In the malls, in the cinema halls, in functions, in festivals, they saw these diversities. So why not allow them to have a few hours in the classroom where there is similarity, where there is uniformity, so that they can have a feeling that, oh my God, despite all these diversities which we witness in the streets, on roads, in festivals, still we are one. So why not allow them to grow with this feeling? Apart from this, there are certain other legal questions also. One is that it has been established that there must be a balance between fundamental right and fundamental duties. It has been said that when certain steps of the government of India or any state government is appearing to be promoting the fundamental duty, so that step can be taken as a reasonable restriction on the fundamental right. And here, Article 51, the fundamental duty, it says that it is the duty of every citizen to bring harmony transcending the religious diversity. I mean, beyond the religious diversities also, it is the duty of the citizen to try to bring harmony. In addition to all these things, there are certain verdicts which are extremely important of High Court or Supreme Court verdicts. One was the Jammu and Kashmir Education Board versus Fayaz Ahmed. In that verdict, it was said that the court should interfere with the regulations of school at minimal level. The second verdict was Bihar Madrasa Education Board versus Hanifiya Arabi College. There also the verdict was that it is the right of a state to regulate even the minority educational institutions. In the St. Xavier's, Ahmedabad St. Xavier's Education Society versus State of Gujarat, the court had said that these regulations in the school or in the college are in the larger interest of students. So these are the questions which are arising in the context of the verdict given by Justice Dhulia. I hope that in the days to come, these questions will be addressed and the citizens of this country will be made aware that what is the stand of the judiciary on these questions. Thank you very much for watching this video, this discussion, this analysis. Please subscribe this channel, and till I come back with a new analysis on some new topic, thank you very much. Have a great time and good luck. Thank you.